best-selling author John Gilstrap.
Good morning.
She is soon to be labeled a quitter. She's going to retire soon.
Thanks a lot, Rob.
She joins Bill Kearns as a quitter.
I wouldn't call myself that.
Bill
but
Stubblefield,
okay.
he quit.
I have all kinds of things to do.
Another word is for retirement.
But I have to say, someone in my exercise class this morning asked me if I'm counting the days, and I was like, no, I have too much to do.
Yeah, lots to do. A lot to do, a little bit of time to do.
If you're not counting the days, it's not time to quit.
Yeah, I know.
Yeah.
I know. People have said that, but it is. I told someone that I looked around the table at a recent senior management meeting, and I had 20 to 25 years on the rest of the senior managers around the table. So,
are you going to call your replacement every day and tell them what they're doing wrong?
No. That's not my style.
I know Maria. She'll pick something else to do, and then she'll do it 100%.
There you go.
I understand you are going to go do that walk again and do the whole thing?
I am. So from Easter Monday until probably mid-May or so, it'll be 6 weeks. We're going to walk across France and across Spain, really. We start in France, and then it's 400 miles.
Is that the entirety of the trail?
It is.
Oh,
yeah.
My goodness.
So it'll be something. Yeah.
Well, good luck to you.
Thank you.
And make sure you call and do a lot of interviews.
I
with us.
will. I'll be happy to do that.
That'd be fun. Let's welcome in our guest, Chief Magistrate Darrell Shull. Good morning, sir. Thanks for coming in.
Good morning. It's good to be here. And Maria, much like in baseball, the most valuable player is the designated quitter. So,
okay.
Yeah, so that's the word I came up with for retirement.
Okay.
You're retiring.
Hey,
you're
not going to probably be too terribly far behind.
Oh, I'll be a quitter again myself soon.
Okay.
Yeah.
All right.
Or whatever soon is defined as.
Yeah. And that's what I said.
My
soon was defined about 3 years ago, and then I kept, and I'm kind of like, now.
So I'm the only one who works forever?
Yes. Apparently.
Well, when you don't get paid, it's not work.
Darrell has been a designated quitter a couple times and has been called back from the bench.
Just when you think you're out, you're back in.
You're back in. Now, so here's my question to you, sir, because I tried to get a definition from Joe Kinzer on this yesterday, the prosecuting attorney, and I don't know if it was successfully defined or not. Cashless bail, because we're going to begin doing a few segments on this topic in the near future, and I figure we might as well start with you.
Cashless bail is not a legal term. It's a political term. And it's a political term that in some angles is supposed to be a positive thing, and in other angles it's a brush you use to paint all that's wrong in the world from your perspective. It's not a legal term. Mm-hmm. Cash bail is.
Right.
And I can talk about what Chapter 62 in West Virginia Code says about cash bail and the forms of bail.
When people talk in political terms about cashless bail, what are they really saying?
So I think what they're doing is they're conflating a lot of different situations. The situation where people are being released on their personal recognizance, or legislatures are mandating that certain crimes are released no matter what. And they're conflating that with judges that are releasing people after sentencing with time served or some other sentence that doesn't require any time in jail. And it varies from state to state and jurisdiction to jurisdiction based on what their laws are. I think if you're applying cashless bail to West Virginia, you might be talking about when people are released on personal recognizance or supervised release or other things where they don't have to post any sort of surety to be released. And there are circumstances where that's appropriate. There are circumstances where it isn't.
Can you take us through a few of those so we understand it better?
Well, sure thing. So under bail terms, bail options are set by the legislature as they should be. It's the legislature's choice as to how you address those things. For nonviolent misdemeanors, mostly, the legislature encourages release on personal recognizance, but they give wide discretion to the magistrates to be able to look at the circumstances. So when I have somebody coming before me who's been arrested and I'm seeing them either at the courthouse or at the jail, I don't have any attorneys in the room. Their defense attorney's not there, the prosecutor's not there. I'm making a judgment based on what I know about that person, their criminal record, and I'm looking at things like, have you committed similar offenses in the past? the nature of the offense. If you offend again, is there a remedy that fixes it? And an example of that is if you're shoplifting, you can reimburse the cost of the material that you're taking. If you're sexually abusing a child, there's not a remedy to that. And so I look at those factors. Do you have ties to the community that are going to make you likely to come back into court? And that's where the option of cash bail,
As opposed to fleeing.
As opposed to fleeing, and that's where the value of cash bail comes into play. So, what are signs that somebody has ties to the community? They own a home here, they have family here who can assist them in posting bail. They have a job, they have other assets that they can put up. If you don't have family here, if you don't have a home here, if you've lived here for a short amount of time and you rent, or you're without a home, you have very few ties to the community, and it's less likely you're going to show up in court. What options do we have in setting bail? I think in some jurisdictions around the country, they've said those people shouldn't be penalized because they don't have resources to be able to post their bail. But I think in other areas, and West Virginia looks at it this way, if you have no ties to the community, you are a flight risk. And so we have to look at other options.
In regards to resources to post bail, so you brought that up as a factor, right? How big of a factor is that compared to everything else?
I can tell you in my court, I don't look at that initially. The factors I look at are, first, how likely are you to show up for your court hearing? And factors that I look at in that to determine that, have you failed to appear before? If you've never been arrested, if you have no criminal record, or if you've never failed to appear, it's pretty likely I'm going to presume you're going to show up for your court. The second is the seriousness of and nature of the charges that have been levied against you. If it's a very serious crime, I'm going to look a little bit more about leaning towards some form of bail they have to post, and then what are the odds of you reoffending? And a couple of lesser considerations. If you're released on bail, will you be destroying evidence before you come into court? That rarely is a factor. Then I look at what's your option to be able to post. Under West Virginia law, and the prosecutor mentioned this yesterday, on a misdemeanor charge, if you're held with bail and you're unable to post bail, we're going to have a hearing on that within 5 days. And at that hearing, we're going to have attorneys to represent you. Chief Judge McLaughlin very kindly issued an order that said the public defender will represent every misdemeanor defendant on bail review hearings so that everybody has counsel available at that hearing. And the prosecutor is there, and the magistrate or judge then can make a more informed decision getting input from these various areas and can decide if it's a drug offense, perhaps a condition of being released on personal recognizance is you report to the Day Report Center. And with Day Report Center, you show up every few days, you pee in a cup, all of those things you do at Day Report Center, and it's a form of supervised release. Or if we're concerned about flight, we have a home confinement order to put a GPS monitor on you so we can follow you. I don't think anybody wants to keep someone in jail just because they have no money and they're not a flight risk and they're not a harm to other individuals in the community or themselves. And we're going to find every opportunity to release them. But in situations where they may be a flight risk or they're a harm to others or themselves, we're going to look for every situation to keep them confined for the safety of the community and their response to the court. I think the political response to the term cashless bail is because in some jurisdictions that discretion of the judge or magistrate has been taken away by the legislature.
So the judge doesn't have the discretion to set an appropriate amount of bail?
My understanding is that in some jurisdictions, there's a classification of crimes, and in some jurisdictions that includes simple assault, which I tend to think is a rather serious offense.
Especially if you're the person who's been assaulted.
That's correct, and it's an indicator of other violence potentially. But simple assault is a mandatory release in some jurisdictions around the country, not in West Virginia.
All right, Mr. Gilstrap.
Well, I think this is the interest of this is born out of that attack in Charlotte where the guy had 14, I believe, previous violent incidents and was let go. So is it possible anymore to, when I was a kid, which was quite some time ago, if somebody was caught in the act of shoplifting, like a kid was caught in the act of shoplifting, the vendor would call the police, hold the kid, the police would come, there'd be that scary moment, and then the kid would be let go, or the parents would be called or whatever, and there would be no official incident. Can that happen anymore? Does there have to be a police report? And
No. And shoplifting on its own is not an indicator that the person is going to commit a violent crime down the road, but quite often when somebody is arrested for shoplifting, there are other offenses that stemmed from the response to the shoplifting. The person flees, the person obstructs the officer, the person refuses to give a fingerprint, the person verbally or physically assaults the loss prevention officer who's talking to them. Those are indicators. So if somebody comes in with a simple shoplifting arrest, or police respond to a simple shoplifting event, they may well just issue a citation, or the store may resolve the issue on the spot. But if the person is obstructing, fleeing, refusing to fingerprint, doing other items that are indicative of a bigger problem, they're going to get arrested.
So, silly little question, maybe. How pervasive is serious, and I guess you need a definition for serious, but what you would consider serious crime in Berkeley County? And how many of those folks do you and the magistrates see perhaps on a weekly, monthly basis?
This may surprise you and a lot of people. If I were to generally assign serious crimes, that's where somebody is a victim of a physical threat or physical violence, where there's serious risk of physical harm. We're looking at a few thousand per year in our state.
does that include bar fights where a couple of yahoos get tanked up and beat on each other?
Well, here's a good example of magistrate discretion in setting bail. So you have a couple of situations. You have somebody sitting in a bar and they see somebody else coming in that they've had a beef with for a while, and they incorporate their other friends around the bar and they beat that person senseless. Mm-hmm. That's a pretty serious crime. You have two neighbors who've been friends for years, and they're watching the ball game, and one likes Pitt and one likes WVU, and they've been drinking all day, and they end up in a slap fest in the hallway, and the police are called. That's a very different situation. I would tend to PR those two individuals if they have no criminal history and they didn't obstruct and refuse to fingerprint and other things, because it's a one-off. It's a terrible thing, but it's a one-off. But the person who recruits their friends and beats someone else, yeah. I had to watch my language there for a moment.
Appreciate that.
That is entirely different. I know your finger is always near the bleep button.
Yes, sir.
So
Usually it's relaxed when there's a magistrate in the room, though.
Now, here's another example. Felonies are very rarely PR'd, and magistrates don't.
Personal reconnaissance.
Personal recognizance. Magistrates don't have a lot of flexibility on felonies. But here's a real-life example without talking too specific about a case. A fellow with no criminal history whatsoever meets a woman on a dating app, and they're going out on a date. They stop off at Walmart because she wants to pick some things up, and while there, she slips merchandise into her purse and walks past the point of sale. She's now been charged with shoplifting, normally a misdemeanor, but she has 2 previous convictions, and now it's a felony. That individual, the man that's with her, that was not involved in the crime, but he's with her and he drives her there and drives her away, is now charged with felony conspiracy because she's charged with a felony. I'm going to PR that guy. You know, he doesn't have a criminal history. I didn't see any criminal intent in the matter. However, property crime is a serious crime, especially if you're a repeat offender, and she is not going to get a PR in that situation.
Does the dollar amount matter?
Third offense does not matter. I've had individuals with third offense felony shoplifting convictions for eating a pickle out of the salad bar without paying for it.
Now,
well, my grandmother would have been in prison. She used to slip us grapes from the supermarket whenever we go to the store with her.
Now, this is interesting because here's a guy who drives a criminal unknowingly, where's the burden of proof at the end? Does he have to prove that he didn't know, or does the state have to prove that he did know?
Well, mensis is always important.
Right.
There has to be intent to commit a crime.
Right.
So there's situations where
Right.
neglect to render aid and that sort of thing, but intent to commit a crime is an important element. And those are facts not known by the magistrate at the time they're setting bail. That's going to come out in trial. But it doesn't seem likely that that individual had intent to commit it. He doesn't have any previous convictions of anything, he or she. And so why should that individual be held on a large bail in jail while awaiting trial? Doesn't make sense.
And let's be clear about this. So hypothetically, I'm admitting to nothing. If one were in Food Lion and one saw grapes that he'd never tasted before, and he's making a decision to buy, and he plucked one of those grapes to taste it, has he just shoplifted, hypothetically, without admitting to anything?
Well, that is up to the store to determine. If the store complains about that, then the officer is going to have to make a determination. The magistrate, the judge, everybody's going to have to make a determination down the road.
Well, it's a good thing I've never done that.
I'm sure. Rob self-admitted, though, that he certainly did.
Yeah,
But
well,
a good
No, that
50 years ago.
that his mother was a...
It was actually my grandmother.
Okay.
She would say, "Open your mouth," and then pop a grape and no say nothing. That would
Well,
do
she
what
came
you
from the
say.
old country. So.
Well, my vast criminal
food.
background, when I was 13 years old, I put a Hostess apple pie in my pocket at Saunders grocery store in our little hometown.
Those little sugary ones that
Yep,
they used to put
that
in
are
the
so
thing.
good.
Oh, they were awesome.
So good.
Awesome.
And I walked out of the store, and I made it a block. And I turned around, went back to the store to Mr. Saunders, and threw myself at the mercy of the store owner. And
The guilt was overwhelming.
it was horrible. That was my criminal history.
When I
That's
was
my
a
full confession.
Kid, I thought those were the greatest things in the world. So I tried one of those as an adult, I don't know, 15 years ago.
Yeah, it's...
And I went, "Oh my, the sugar. What was I thinking?
Yeah.
How did I think that was so good as a kid?" But as a kid, that was the best tasting stuff in the world.
Not the same thing. Now, I will tell you, in West Virginia, under Chapter 62, Article 1C, which is what deals with all of bail conditions, there's really three types of bail terms generally in West Virginia. There's cash bail, there's no bail, if you commit murder or kidnapping or treason. We don't get very many treason cases in magistrate court. There's no bail available to you from the magistrate in those cases. Everything else is recognizance, and we tend to, again, confuse what recognizance means. Recognizance means I'm going to trust you, Maria, to come back on your personal recognizance, or it means I'm going to release you to the custody of John, and he's going to watch you like a hawk and make sure you come to court, or you're going to use a bonding company who's going to be responsible for you coming back to court, or you're going to post cash or property or a bond of some sort of a value, monetary value, to make sure you come back to court. Those are all recognizance issues. And I think, again, some of the political discussion about cashless bail doesn't look at the recognizance side. They look at those areas where the categories of no bail are drastically expanded. And in West Virginia, like I say, it's really only those crimes that are potential life sentences are no bail situations in West Virginia.
If you addressed this already, I apologize for re-asking the question. But when you set bail, are there hard and fast guidelines that you follow for the dollar amount in regards to the offense and the number of offenses and the person's history?
Again, our legislature has the purview to set those things, and as they should, and they've also been very good at allowing discretion of the magistrate or the judge to adjust as necessary. So the hard and fast in code requirement is if you're setting cash only as the bail term, that can be no more than 3 times the maximum possible cash penalty for any offense in that crime. So say...
And those cash penalties are set by the legislature?
They are. So say you're arrested for domestic battery, and you have 3 other charges associated with that, drunk driving, other things. We can only look at the maximum cash penalty of any single charge and then multiply that by 3. And in most cases, that would be the domestic battery charge. The maximum cash penalty on domestic battery is only a few $100s. So the maximum cash bail you can set is about $1,500.
So when this news comes out that this person who we think did something that's horrible is released and the bail was $1,500, the anger shouldn't be directed at you. It should be directed at the legislature?
If I set that bail as cash only, but if I set it in some other term as a bail bonds situation, I can set it for $5 billion. There's no restriction on that. Now, in Berkeley County, we've made a real effort to somewhat standardize the bail amounts we set based on the crime. And generally, it's set at 3 times. No matter the type of bail you're doing, it's set at between 1 and 3 times the maximum amount of cash penalty you could face. And all the magistrates can somewhat follow that. And if we deviate from that, we're self-policing ourselves, and we put written findings why we're deviating from that into the bail agreement. You have a previous history, you're currently out on probation for another charge, whatever it might be. So that when we have that bond review hearing, or when the case is appealed down the road or the bond is appealed to circuit court, there are actual written findings as to why we made that determination. And again, I thank the legislature for giving us and maintaining that flexibility to look at the circumstances of the case. I'll set bail this year 1,000 times in a year. And I may make mistakes in that process. But I can't overlook the fact that our Constitution guarantees everyone, unless you're facing a potential life sentence, the right to have reasonable bail set. And I have to do that while balancing public safety, the safety of the individual, and the rights of the individual.
Is there any pressure on you to keep jail costs down to the taxpayer in regards to whether or not you're setting a bail that might be, or a bond that's so high it might keep a person in jail?
There's no pressure on me, but I think there's a public responsibility on me and the other magistrates to do exactly that. And we have, over the last 8 months, by standardizing the bail amounts we've done, by coming up with a bail review process that brings the defendants in sooner with an attorney so that we can look at their bail situation. I'm proud to say that Berkeley County Magistrate Court has been able to reduce the jail bill by reducing the number of people that are incarcerated needlessly while awaiting trial by a little over $500,000 a year. Significant amount of money that can go to public safety resources and other resources. And we haven't seen an increase in failures to appear because of that. But we're also cognizant that we're not going to extend that. That's not going to be the only factor. If you have harmed a child, well, here is a hypothetical example. A grandfather is arrested for sodomizing his grandson. Terrible, terrible crime. And is released on bail and commits another offense with another grandson. There is no remedy to that child for that offense. So that is the first and foremost consideration that I put in, is what is the harm to the individual while balancing the rights of the accused to have bail. Then they're tough choices. Joe Kinzer was exactly right yesterday when he said when he's asked for a recommendation, he hates that moment.
Yes.
Because you're dealing with the life of the person who's accused, and surprisingly, we do arrest people that are innocent sometimes. And surprisingly, sometimes we arrest people that are guilty. But you're balancing the rights of that individual with the rights of the public to be safe. And that is a tough responsibility.
And I think from a public perspective, so many people forget about that key point that you are innocent until proven guilty, and throw them in jail and throw away the key and all the things. And, yet it's a really difficult decision that you all have to make.
It's a very good thing we don't determine justice by social media posts, because we often think of bail as punishment. Bail can never be punishment.
Chief Magistrate Darrell Shull, always a good segment. You're very, very good at this.
I didn't bring any goodies for you, though, so that detracts from the overall goodness of the segment.
It's been a good goodies week, so to speak, so there's a good stockpile in the fridge.
And there's a beautiful rain coming down, so that's good news also.
We go to the top of the hour. Thank you, sir.
Thank you.